Okay, good morning everyone. Thank you for joining us today. Welcome to our TOLATA focused family brunch with 3PB. Great to see so many of you joining us for quite a technical and niche area of law. So we will be taking questions at the end of this seminar. If you would like to post any questions in the Q&A box, we will try to answer as many as we can either throughout the presentation or at the end. And we will be distributing our presentations after the event as well. Without further ado, my name is Rachel Bale and I have with me Luke Nelson, and we'll be giving two talks today. Firstly, on the general overview, Practitioner's Guide to TOLATA Claims, and then looking at the interface between TOLATA and Inheritance Act claims as well. Firstly, Luke Nelson, called in 2017, Luke is a financial remedies and TOLATA specialist. He is also comfortable undertaking lots of other chancery work such as probate and Inheritance Act claims. Luke is a skilled mediation and trial advocate and able to advise generally on all aspects of TOLATA. So he's a perfect fit for today's morning seminar. And Luke was nominated a few months ago as Rising Star 2024 in this year's Legal 500 directories. So I will now pass over to Luke for his presentation. Thank you.
Thanks, Rachel, and good morning, everyone. For those of you that have attended one of my talks at these brunches before, you might be moaning yet another TOLATA talk. This one is slightly different to the last one, in which I focused a bit more on a sort of client management point of view, looking a bit more into the nitty-gritty. Today's talk is going to focus on the broad aspects of the relevant law that you're most likely to come across in your average TOLATA claim. Not a huge emphasis on lots of case law, but more what generally that case law has taught us. So, first point is going to be, well, what's different about TOLATA from your average sort of financial remedies case? Second is where the real meat of the talk's going to be, and that's the most common issues that we run into in TOLATA claims. Generally, you're talking constructive trusts, proprietary estoppel, or resulting trusts. And finally, a brief mention on costs, because I know the recent fixed costs reforms has got everyone shaking in their boots a little bit about whether or not that's going to affect things moving forward. So then, what makes TOLATA different? Well, quite a few things really, but just looking at the statute itself to give us an initial starting point, the relevant sections are 12 and 15, the Trusts of Land and Appointment of Trustees Act. Section 14 sets out the court's general powers. There are really two things. The first, declaring beneficial interest in the property, so it's a declaratory power. And second is taking whatever actions the trustees could take. And that, we'll see, can provide some interesting twists and turns, because you can't ask the court to do the same sort of property adjustments that you might be asking them to make in a matrimonial finance case. One of the things that the court can do, however, is effectively charging occupation rent, and that's subject to section 13 of the Act. Section 15, again, very whistle-stop tour. They're the factors that the court's going to take into account. It's the intentions of the parties, the purpose of the trust, whether there are any minor children present, and the interests of any secured creditors. The reality of it is, in most of the cases that we might find that we're dealing with as sort of family/chancery professionals, is that section 15 is going to come more into play when you talk about whether or not to make an order for sale. The main bulk of most disputes is going to be this long history of case law, all the names that we know and love, Stack and Dowden, Jones and Kernet, Gissing and Gissing, etc. So then, looking at that, What makes it different is, well, it's declaratory for the most part. It's not redistributive. And of course, that we're all familiar with the court's redistributive powers under the MCA. Not so here. The court can only declare what the parties intended, save for a couple of examples, which we'll talk about, the most prominent of which is proprietary estoppel, which rather than a declaration under TOLATA is actually an equitable remedy that the court is able to exercise if it so wishes. Civil procedure rules apply. Now, that's usually the main point that terrifies most family lawyers because, as we all know, however much we hate to admit it, the FPR seems to be more of a suggestion than a rule. Not so in civil cases. There are serious consequences for failing to comply with the CPR. You've got to be aware of the dates that are built into the CPR, not just the orders you're sent by the court. I had a case recently that was unfortunately struck out because the solicitors didn't file a reply and defence to counterclaim in time. That was an otherwise runner of a TOLATA case that fell at the first hurdle because of failing to comply with court deadlines. So it's really, really important to be aware of the CPR. When in doubt, you'd be surprised to hear this from a barrister: seek the advice of counsel and get them to do it. Thirdly, there is much more of a focus on the intentions of the parties in these cases. Obviously, Matrimonial Causes Act work is the court's general quasi-inquisitorial jurisdiction as to what it believes is fair. As we'll see in TOLATA cases, what the court thinks fair is only going to arise in the rarest of cases, and that's when we come to imputing the quantum of someone's beneficial interest. And fourthly, we're looking at principles of equity. TOLATA cases are principally heard in the Chancery courts. So before we delve into the law proper, where do you start when the client first walks through the door? You need your office copy entries, your TR1. TR1, for those of you who don't know, is the transfer of land document. Especially important in TR1 is the fact that within the document, there is the potential for an express declaration of trust. If the property was conveyed into two people's names, and those are the two people who are arguing, and there is an express declaration of trust in the TR1, that's most often determinative. And so that's a really, really important document to obtain. Similarly, the conveyancing file, it can tell you a great deal about the intentions of the parties at the time, whether both were involved in discussions with the solicitors, and so on. You may find that you're for a client who isn't named on the title, and therefore you're not strictly entitled to the conveyancing file. In such circumstances, what you really want to be doing is putting a timely request to the other side that it be disclosed. And if that goes sideways, you might be thinking about an application for pre-action disclosure. Otherwise, you're going to be issuing proceedings and referring back to it on the issue of costs. And as we will see very soon, one of the best things to get your hands on, if they're available, are contemporaneous notes, messages, emails, letters between the parties, which give some insight as to their intention. So a brief word, I mentioned express trusts in TR1. Generally, express trusts are conclusive. The case law is very clear on this now. If parties have signed a declaration of trust, and that could be a formal document, headed declaration of trust, or it could simply be box 10 of the TR1 that says we hold the property as joint tenants in equal shares, or whatever else they may have agreed. That is determinative, save for certain specific circumstances. Those are a proprietary estoppel, which is why it can always be helpful to plead that in the alternative. particularly if you don't have all the papers, or if you're seeking to set aside the deed on the basis of your standard vitiating factors, sort of fraud, undue influence, etc. But if you've got an express trust in the case you're trying to set it aside, then the wind is very much against you. You're going to find that quite difficult. Constructive trusts particularly cannot exist where there exists an express trust between the parties. That's old law, goes back to the I think it's Pettit and Pettit in 1970, so before the Matrimonial Causes Act even. It's been reiterated throughout the years. There is one case that hungry lawyers might find by the name of Clark and Meadus, which is a 2010 case in the High Court, which it was a successful appeal against strikeout in which constructive trust was argued. In that case, the judge asserted or queried whether there might exist a remedial constructive trust. English law does not recognise a remedial constructive trust. As far as we're concerned, we are declaring what happened, not imposing a remedy. So if you ever see an opponent relying on Clark and Meadus to say, aha, well, we've got a constructive trust where there was an express trust, you can tell them to go away. That's not right. Sometimes you might have to tell the judge that. So then, the main offender in these cases is the common intention constructive trust. There are three ingredients. That is the intention of the parties, reliance upon that intention, and detriment. Now, I find it useful in these cases to apply intention effectively in two ways. And this is where you get the difference between sole name and joint names cases. In short, the difference is if, say, you're for a party who isn't named on the title, their partner is, they have an additional hurdle to overcome, and that is they must prove in the first instance that there existed an intention that they should be named or they should be entitled to a beneficial interest in the property. Hence, existence variation. So firstly, was there an intention that either an unnamed party have a beneficial interest? Or secondly, if it's a joint names case, was there an intention that the joint owners of the property were to hold it in beneficial shares that differed to your standard sort of 50-50 joint tenancy in common? And then, of course, you also need to consider the intention insofar as quantum is concerned. That is relevant when we go further into intention, how we discern what the party's intentions were. So then, how does one find out what the parties intended? There are really, when one talks about existence or variation of a beneficial interest, the course is going to be looking at express discussions or whether it can infer an intention through other means. That tends to be by contributions, or it can be all the circumstances of the case. Whether or not, sorry, let me rephrase that. As for an imputation, which is where the court says what it thinks is fair, the court cannot impute a beneficial interest. That would go beyond its jurisdiction under the Act. The court can only impute intention when it comes to consider the quantum, i.e., are the parties entitled to 50% shares, or is it 25%, 75%, etc.? So really what you're looking at in this slide is a list of priority evidence. Best thing you can hope for in a case is evidence of express discussions between the parties. If you come across a case where someone has an email that says, my darling, of course, I entitle you to 50% of the beneficial interest in this property. I consider that binding in law and equity. Then you've got a smashing case. I've never seen one, but it theoretically can happen. Where most cases will be determined is the implication inference phase. And that is when the court looks generally at the course of dealing between the parties. It can look at things that were said that might be more equivocal or even less so, or contributions made by the parties. That could be directly by way of financial contribution to renovations, or more indirect, for example, carrying out significant manual labour on the property. So let's say, for example, there are no express discussions, or as happens in most cases, both parties assert that there are polar opposite express discussions. One party says, well, he said I could have 50% of the property, and the other party says, no, I said it would simply be our home, and I meant that as in just where we would live, but I put all the money in, so it's mine. The court may then look at the discussions between the parties in light of the other evidence. And when one's looking for clear and unambiguous language to assert the existence of a common intention, for example, like the first example I gave, it may only have more ambiguous discussions to grapple with. The age-old example is, or message is, at the time of the purchase saying, I can't wait to move into our home, or, you know, this is ours, all ours, words to that effect, you know, or discussions with third parties when they refer to themselves as we or us buying the property. Now, that necessarily can be interpreted in two ways. And so the court's going to look at those words on an objective basis. So the test isn't what the parties actually thought, the test is what the words they said would mean to an objective observer. And this is where you can get these problems advising clients when they may well have genuinely thought they were not handing away the beneficial interest in the property. But the court might find that regardless of whether they thought they were doing so, the words they used would have caused the reasonable objective observer to think so. And this is where you can get a bit creative. You know, if people are purchasing a property and they're discussing with maybe architects or builders to make some changes to it, and they refer to themselves as we, or this is our property, and the architect makes an assumption, writes to them both that, you know, we're doing this for your property, that might be utilised to argue in favour of the existence of common intention. Once you've got over the hurdle of existence or variation of the standard beneficial interest, you then turn to what were the parties' intentions insofar as quantum is concerned. And the court uses the exact same sources of evidence as they do for the existence and variation points, save that they have the additional string to their bow of an imputation. Now, imputation is only available as a last resort for quantifying beneficial interests. The court can only do so if it lacks sufficient evidence from which it can find that there were express discussions or from which it can infer a common intention. When imputing the quantum as between the parties, the court's going to look at the whole course of dealings between the parties and consider what it thinks fair in light of all of that. And so that's the one exception that we find to the court exercising a degree of subjective fairness. You take it that way. So as you can see, common intention is a bit of a pain. It's going to be your heaviest factual issue, most likely. You need to be looking at a lot of contemporaneous evidence, take clear instructions from your clients so you can work out, well, what do we say was an express discussion? From what evidence can we ask the court to impute the existence or non-existence of a common intention constructive trust. Second ingredient is reliance. This tends to run alongside detriment. If detriment is proved, you're likely to find that reliance follows it. But it's not something that you should just simply admit in your pleadings or not put any amount of time into it. I recall a case in which the parties had an adult son who was blind. The woman's case was that, well, the woman's case on the papers was that she had spent a lot of money renovating the garden because she believed she had a beneficial interest in the property. Through the course of my cross-examination, she accepted that the reason she did those renovations was because her son was blind, he needed a more safe environment, and no matter where she lived, she would have carried out those renovations. That was a nice little moment, but it's thoughts like that can really save a case sometimes, because there must be a sufficient causal link between the asserted intention or assurance and the detriment suffered. Conscious I've been yabbering on for quite some time. I'm nearly out of time, so I'm going to try and speed this up even further. So apologies, all of you. Detriment, it's still required. There was some talk about this in the High Court decision in Hudson Hathaway, but the Court of Appeal roundly rejected that assertion. Detriment is indeed still required. It's got to be substantial, doesn't necessarily need to be directly equivalent to the share that you seek, but it has to be significant. You can't just say, well, you know, I moved in, I paid £100 a month, and that's it. There needs to be something a little bit more to it. You could argue a variety of things at detriment. It could be giving up a flat. It could be simple as expending money. It could be lost opportunities. It's an opportunity for you to be a bit creative in your pleadings if need be. I make reference to direct and indirect contributions because you'll often find, as with most things in equity, there's a degree of overlap. So what you're relying upon for your detriment also doubles as what you're relying upon from which the court can impute a common intention. So that's really important. Right, now that everyone's brains melted from common intention, constructive trust, proprietary estoppel, I'll deal with this quite quickly. It's actually an equitable remedy, as I previously stated. It doesn't fall within the court's jurisdiction under TOLATA, i.e. it's a sort of freestanding remedy to which the court can avail itself. It allows the court to determine what was fair in the circumstances. So if it finds, for example, that no, there was no common intention, that you hold the property in these shares at the time of purchase. However, on hearing of the evidence, the court thinks, well, this is fair, and so this is the proprietary estoppel that I'm going to permit. Almost always worth pleading alongside common intention constructive trust. You may as well, because the test is almost identical. Proprietary estoppel test is an assurance, reliance, and detriment. Assurance is effectively the same sort of test as common intention. What you need is a sufficiently clear and unambiguous assurance that relates to specified land. Things like saying you'll be looked after or you'll have a roof over your head aren't going to cut it for an assurance. It needs to be relating to the land itself. And that's why most often you'll be running your claim on the basis of a constructive trust, but you can also argue in the alternative that if there's not a constructive trust, then the court should exercise its powers under proprietary estoppel. Resulting trusts, very briefly, this is the third point. Generally, we won't be relying on resulting trusts in the sort of TOLATA work that we do. You know, cohabitees in their sole property. That was roundly rejected in Stack and Dowden. The majority of the House of Lords said no, it should be. We should be considering these by constructive trust principles. But if you're looking at cases when there's more than one property, investment properties and the like, it might be worth pleading alongside. What effectively it means is that the investment that was initially made jumps back. So you're not going to be arguing a resulting trust if you've not made any direct contributions in money to the property. But it will usually be treated only in sort of pounds and pence. And so you can see why it's a bit less compelling than constructive trust, which you might be arguing for a percentage share of the property. Resulting trust is a rebuttable presumption. It can be rebutted by the counter presumption of advancement, i.e. that it was intended as a gift, or through direct evidence of an alternative intention. And so that's where you can see it mixes in with what you'll be arguing for common intention. And just before you thought it would get any worse, we talk about costs. Very briefly, because I suspect, I know where everyone's going to be concerned, but you've got to be advising your clients robustly from the start. You need as much evidence as possible. Conference with counsel at the earliest possible stage is a must in my view, because the cost consequences in most cases are likely to be severe. You need to be considering very carefully, putting forward sensible offers on either a Part 36 or a Calder Bank basis. My general advice in most TOLATA cases is get it mediated. If you go, you get lawyer-supported mediation in front of a sensible mediator, you tend to be able to find a conclusion that works for everyone. Civil procedure rules apply, of course, so the court has general discretion, considers the conduct of the parties, success, admissible offers to settle. That's where we consider Calder Banks, etc. But generally, the winner gets their costs. Bear in mind, if you're preparing a summary cost schedule, in cases when you're not doing cost budgeting, there are certain deadlines you've got to comply with. Do try and do that if you can, because I have seen judges punt things off because cost schedules haven't been put in, and you don't want to be stuck trying to agree costs with the other side. I suspect we'll deal with this in the Q&As. I appreciate I don't want to run too much into Rachel's time, but what of the fixed costs reforms? We all know about them. Are they going to affect these cases? Well, strictly not. Most TOLATA matters should, as a matter of course, actually be Part 8 proceedings. If you look at CPR 64, we all know that when there are substantial disputes of fact, they aren't, and it's Part 7. But generally speaking, because of the sums of money involved and the fact that it's declaratory relief, you're looking at multi-track cases. And therefore, at a starting point, you're unlikely to be arguing about fixed costs. However, be mindful of the amendments to CPR 26 and 28, which deals with the intermediate track. There is some argument that TOLATA cases could fall within that track. However, if the relief you seek includes non-monetary relief, and in TOLATA cases that's almost always a declaration, then the intermediate track isn't the right one to go on. If you want the reference, it's CPR 26 subparagraph 8. So that may very well be what you try and rely on if the judge says, well, you sure you can't get this into intermediate and get fixed costs? Anyway, I'm so sorry. That was a bit of a canter towards the end. I now pass on to Rachel and we'll deal with any other questions about this topic at the end. Thanks for bearing with me.
Thanks, Luke. I don't think anyone was bearing with you. Very interesting. Right, I'll now attempt to share my screen.
That's your note section.
Yeah. Can you see my full section?
We're good, Rachel. Yeah.
Okie dokie. Thank you very much to Luke. So everyone, if you can bear to hear any more TOLATA, I'll now be discussing the interaction between TOLATA and Inheritance Act claims, and where it may pop up either claim, both claims, or the choice between the two. So in terms of the agenda for my talk, an overview of the Inheritance Act 1975 claims, which types of cases may engage both TOLATA and the Inheritance Act, a brief guidance to procedural approach really, and some tips that you might want to consider before taking the plunge of an Inheritance Act claim, and costs. I will be mopping up a little bit of what Luke said with regards to any implications of the fixed recoverable costs as well, because I note a sense of panic amongst the legal profession as to this implementation, which happened on the 1st of October. So Inheritance Act claims then. Interestingly, there is a real growing trend of Inheritance Act claims. I've got some figures from 2021, some more recent ones aren't quite available at the moment, but there was a 72% increase from the year before, which is shocking. I suppose lockdown perhaps had something to do with. And challenges to the distribution of estates, again, 37% increase. So we are seeing quite a lot of movement in this area. And also, I would say, it's not necessarily for high value net worth estates. It can be for the lower or mid end, which is something to bear in mind with the types of clients that you may be getting. So what is it? It's a mechanism where applicants can seek reasonable financial provision from a deceased estate where none has been provided for them. And this can either be in the case of where there has been a will, a duly executed will, or perhaps the deceased has died intestate. So I'll briefly run through the main points when bringing such a claim. I'll go through who can bring a type of action, what do we mean, or how's the court's approaching this idea of reasonable provision, and then a quick overview of Section 3 factors. What will the court be looking at? So who? This is probably one of the more important things to recognise. Not everyone can bring an Inheritance Act claim. There are a very set defined list or a class of applicants, which I've noted there, about 5 different classes. A spouse or civil partner being quite an obvious and probably the most, the highest form of applicant that applies. Then we have a former spouse or formal civil partner. However, that may be implicated by the fact that they have now remarried or become involved with a civil partnership. A child of the deceased, also fairly obvious, but also this wider netting of a person who was treated by the deceased as a child, and that can encompass a great many deal of people. It may be a relative, it may be a foster child, it may be an adopted child. The pool widens on that one. And then finally, this catch-all of any person not included in the above, who immediately before the death of the deceased was being maintained, either wholly or partly. And that's quite an interesting addition, I would say, to the class of applicants, because that can encompass a great deal of many people. What I would say on this is there is a 2-year rule, so immediately 2 years prior to the death of the deceased, they needed to have been maintaining this person, and this of course will be very dependent on the facts and the evidence provided by the client and through cross-examination as well. Okay, reasonable provision. What will the court be looking at? So it's a 2-part test, really. Quite simply, did the will or intestacy make reasonable provision for the applicant? And if they didn't, then what reasonable provision ought to now be made for them? And really, the court's task in this is weighing up a really big principle of testamentary freedom or capacity in terms of making your wishes before you die and those being abided by, but also this idea of reasonableness and fairness, and especially when looking perhaps at a child who's been left out of a will, is it reasonable in all of the circumstances for that to continue? So you can see a real underpinning of equitable principles, trusts, and a similarity in the approach, I suppose, of TOLATA in this idea of fairness in all of the circumstance. I've put a case at the bottom, Illot and Blue Cross 2017, it's a Supreme Court case, probably still one of the more famous cases for Inheritance Act claims. And I just think it's a really interesting depiction of how the court approached it. 3 different courts approached it in 3, I suppose, different ways. the facts are these. Mrs. Illott was the applicant. Her mother died, so we're dealing with her mother's estate. Now, she had been estranged from her mother for 26 years preceding the death, and it was always known that she wasn't going to be provided for within the will since as early as 1984. So no great surprise that nothing was provided for her. The estrangement began when Mrs. Illott left to go live with her husband at 17 years old. But interestingly, in this case, Mrs. Illott had only a net annual income of around £20,000. She was only receiving benefits, disability benefits, and a number of other things. So a much lower wealth than her mother. And the courts looked at all of these factors, looked at the fact that no provision had been made for her, and did decide that she should get a claim. Mrs. Illott should get something, and awarded her £50,000 in the circumstances. Court of Appeal, when this was challenged, because Mrs. Illott said it was too low, the Court of Appeal agreed with her and actually increased the amount to £143,000 to allow her to buy the home that she lived in. And also gave her a further option to receive £20,000 at a later date. Now, this went all the way to the Supreme Court in 2017, who, surprisingly in lots of ways, set aside the Court of Appeal's decision and reinstated the deputy district judge's award of £50,000. And they say two things about it, which I think really depicts this tension between the principles I've mentioned. So the Act does not require the judge to fix some hypothetical standard of reasonable provision and then increase it or decrease it with regards to variable factors. What it should be doing, and what the district judge did do, is consider all of the Section 3 factors so far as they're relevant, and was very much entitled to take into account the relationship between Mrs. Illott and her mother, the estrangement, and Mrs. Jackson's wishes at the end of the day. And I think that's quite a good depiction, really, of how the courts will approach this when looking at the Section 3 factors. So what they will be looking at, as placed on the screen, the financial resources, not just of the applicant, who may be on a low income, but also of the beneficiaries, the other people that have received from the estate, and any other potential applicants. So if there are other siblings or perhaps ex-wives or ex-husbands that may come out of the woodwork, what are their financial circumstances as well? Also looking at the obligations of the deceased. So do they have any provision to care for this applicant, normally in the case of parent-child? The size of the estate will always be a factor. And then looking at any kind of disability of the applicant or any other parties. And finally, the catch-all, very clear, equitable point here, any other matter in all of the circumstances, including the conduct. So this, I suppose, Illott is an example of conduct between Mrs. Illott and her mother, and how that would affect as well. So that just gives a rundown of how the court will approach these cases and the things that you might need to bear in mind to prove for your application. A nice other point to raise, Section 9, it's a little bit technical, but I think it's worth mentioning as an overview. This is a section that can be relied upon where a deceased person who was beneficially entitled to a joint tenancy of a property, now casting our mind back to landlord lectures, joint tenancy where if there's two, let's say two joint tenants, where one dies, the entire equity, the entire whole passes over through survivorship to the other joint tenant. But Section 9, what it allows the court to do, it allows the court to sever that share as if they were tenants in common, so there'd be 50-50, and for that severed share to then form part of the deceased estate. So if I break that down by quite an explanatory case, really, Begg and Begg, 2021, it's a High Court case. What happened in this case? There was the deceased owned a property with his brother. They were joint tenants. At the time of his death, the deceased lived in the property with his wife as their family home. The deceased died. The deceased brother then pursued possession proceedings against the wife to get her out so that he could sell his property that he owned 100% of. She made an application under Section 9, stating that her husband had held this as a joint tenant, and therefore that she should now be entitled to that 50% share, as that share would now be severed under Section 9. she won her case, and the court actually decided, they looked at it more as a monetary terms, and decided that she was entitled to £80,000 as a reasonable provision out of his estate. And the effect of that is that she was able to remain in the property until those funds were paid to her from the estate. They couldn't be paid for because I think the estate was too low, and therefore she was able to remain in the house. So Section 9 is quite a technical point, and I would suggest, if looking to rely on it, advice from counsel probably would be required, but it is a good provision to rely upon, if they're, especially in cases where property may be held by other family members or other people outside of the estate. So another final point to make: the court has a huge discretion to the types of orders that they can give in an Inheritance Act claim. They can provide periodical payments, lump sum payments, they can order for property to be transferred, they can order property to be sold or bought, and they can actually order variations on prenuptial agreements, postnuptial agreements, all of those things if they benefit the applicant. So perhaps a child is making an application against the estate. So a really, really wide discretion, and the world is your oyster, really, in terms of what you're asking the court to do in such a claim. Moving on. Okay, so the interface between the two, which type of case would engage or could potentially engage both TOLATA and an Inheritance Act claim? And I have a case that I recently advised on that may provide a little bit of context to this. So this is a case where my client A was a cohabitee and a partner to a wealthy man named as B. The relationship began in 2019, and they both resided in a £1 million mansion somewhere in the UK. And I should say at this point that my client, she left her job, she left her home in order to embark on this relationship. Now, the B owned the mansion solely, it was in his sole name, paid for everything, paid for the bills, paid for the mortgage, the entire lifestyle was paid by him. He dies in 2023, unfortunately. For some months before that, about 6 months before, A had been caring for him in a real caregiver role. Now, B had left a will, but this was made 10 years prior to the relationship even began. There was provision for his children, but no provision for A. And A obviously came to us saying that she wished to continue living in the mansion. She was under the impression that she would always be provided for. No express conversation so much as this is your home or you will live in the home, but that she would be looked after, essentially. And as most things get triggered by possession proceedings, B's family wanted to sell the property, so they issued possession proceedings to remove her. Now, in this case, what is the approach? Is this a TOLATA case? Is this an Inheritance Act case? Or is it both? And what do we need to look at to decide? Now, looking back at Luke's talk, that you can probably pick out some points here in terms of express constructive trust, or is there an implied constructive trust? And in the end, looking at all of the evidence that we had, it was decided that we should go with an Inheritance Act claim. That was the stronger point. We were concerned as a TOLATA claim. There was no financial provision left for her, despite her being a partner and living as his spouse. And she did want to remain in the property, but this could be a type of order could be provided through B's estate. She'd probably get some sort of financial sum. At the very most, she might be able to get a life interest in the property. But we thought the Inheritance Act claim was a stronger route. We were concerned about TOLATA because A, there was no real evidence of express trust or any kind of intention for it to be expressed. There were definitely no conversations about it in that way. Her contributions, she didn't really contribute either financially to the property or really in any indirect way, apart from, of course, caring for him for those 6 months. So we did grapple with that as a potential situation, but we were concerned, and given the cost implications, we decided that it should be an Inheritance Act claim. If I change a couple of facts, though, for example, if A had been paying towards the mortgage, either half or paying the bills, or A, had paid for renovations or carried out DIY work herself, then that would have changed our opinion. And then we have to look then at the contributions that A did or would have provided, and that would have changed our mind perhaps, and we maybe would have run two together. But I think that's quite a good case of where both claims could be engaged, but you need to have a real conversation as to which one to go with. I also put a note here about, don't forget about proprietary estoppel. Luke's covered that in great detail, so I won't go into any more detail on that given the time. So just giving a breakdown, this is a very, very general breakdown, TOLATA versus Inheritance Act claims. So I wouldn't be taking this as read. It is very fact dependent, but in general, of course, TOLATA is normally between living parties. It doesn't have to be, but you're normally dealing with the ownership of an asset and who owns what and how it should be divided. We've gone through express intentions, implied intentions, but what I think is interesting about TOLATA is you're really looking at and focusing on the applicant's actions. So what was their contributions, either direct or indirect? What were the conversations? What was their conduct? It's all focused on their actions. And then of course you have your section 15 factors. Perhaps there's a child living at the property, that should have some sway. And things such as that. Whereas the Inheritance Act claims, it's slightly different. Firstly, of course, there has to be a death, not to be crude, but there has to be a death to even bring a claim. There is a very defined class of applicants that can bring such a claim. Not everyone, it's not as open. But the real difference here, I would say, is that the focus is on reasonable provision and what's reasonable in all the circumstances. And it looks at other people's not so much actions, but in terms of how much wealth they have, any disabilities. It's not solely focused on the applicant's circumstances. And I think that's quite interesting, the interface between the two. Okay, general guidance then. If you're looking to pursue an Inheritance Act claim, maybe both a TOLATA Inheritance Act claim, you really want to be pursuing all avenues and having a real wide lens before, especially Inheritance Act claims. So, I mean, is there a proprietary estoppel case here that you also want to look at TOLATA? Is that engaged? But also, when looking at Inheritance Acts, is there a challenge to the validity of the deceased will in the first instance? Do we need to be attacking the fact that there is a will and that perhaps there was maybe some undue influence, or perhaps they didn't have capacity at the time, and therefore attacking that first before we can even go to Inheritance Act claim? Or would you do that at the same time? Secondly, with regards to, you also, sorry, I should mention with Inheritance Act claim, you also really want to be thinking, are there any other applicants that may pop out here of the woodwork? Is there perhaps another, a child, a love child perhaps, or an ex-wife, ex-husband that could be making the same claim, because that may have an impact on your case and the costs and how complicated the case may become. So you just want to have a real wide lens before embarking on it. Secondly, is your client a valid applicant for an Inheritance Act claim? Especially in the case of marriages, there is this idea of void marriages, perhaps, or foreign marriages that are not recognised by English courts. You need to investigate that your client is valid. Another thing that pops up often is, for example, someone says that they are a child of the deceased, but they have had no relationship. There may need to be some DNA testing or some sort of proof to provide the link there. Priority of claims. Now, as I think I've mentioned, you can bring both a TOLATA and Inheritance Act claim in tandem if there are reasonable grounds to do so. But also you need to be looking at the priority of claims and which goes first. So as I've mentioned a couple of times, both in my example and also beg and beg, Inheritance Act claims normally get triggered by possession proceedings. Someone tries to get you out of the property or get your client out of the property. What goes first? Well, should they be displaced and then we deal with TOLATA and Inheritance Act later? No is the answer, and I found a very useful case, Moody and Stevenson 1992, which deals with this. It states explicitly that any sort of possession proceeding should be stayed or put on pause so that any TOLATA or Inheritance Act claims can proceed first. So that's an important point to note, and you're welcome, because that took me a very long time to find that case. Where to start a claim? Quite simply, we have the county court or the High Court. Now, the county court has unlimited jurisdiction, interestingly, whatever the value for an Inheritance Act type claim, except if you're also seeking other equitable relief. Now, if you are going to plead proprietary estoppel, that it may go over a certain value, and the value is capped at 350,000 in the county court. So if it's anything above that, you will necessarily have to go to the High Court. Unlikely, but it's worth bearing in mind. Whereas the High Court is normally for cases which are more than £100,000 and deemed to be fairly complex. So you may want to look to start there if it seems sufficiently complex. Okay, another thing definitely to bear in mind, limitation periods. Now, TOLATA is interesting because it's an equitable principle. I was looking at it. It doesn't really seem to be at least a statutory limitation on bringing a claim. Luke may correct me on that, but it's a much wider scope, at least, for bringing a claim. Whereas Inheritance Act, it's very strict. You can only bring a claim 6 months from the date which representation was first taken out, granted probate, or some sort of representation as that. There is some case law, some recent case law, that there is some discretionary relief on that, and that application would have to be made to the court. Really interestingly, a case of Rebusate, it was a 2019 case. The claim was brought 26 years out of time, but given the strength of its claim, the court did allow her to bring it. So there is a little bit of discretion on that, but of course you'd have to prove your case in an application that it would be worth bringing a case so long out of time. And I suppose the last point is there are some further resources on this. I would highly recommend the Dictionary of TOLATA and Inheritance Act Claims. It's by Class Legal. It's a really good resource just to get your head around some key principles. But also, I have to echo Luke, for Inheritance Act claims, you want to be getting advice from counsel pretty early on, a conference with clients. As I say, this wide lens of potential consequences that might happen in these claims. It can get quite expensive quite quickly, so I would suggest specialist advice, ideally from a practitioner that does both TOLATA and Inheritance Act claims. My final point then, I need to leave a bit of time for questions. So costs we have gone through. My only additional point is, when it comes to Inheritance Act claims, note CPR 46.3, personal representatives can be paid, or should be paid, costs of proceedings from the estate on the indemnity basis. So you may want to bear that in mind if you have a claim and you lose against an estate. Your costs will be on the indemnity basis. So again, you want to be always keeping that in mind with regards to costs. Fixed recoverable costs as well. Again, it's unlikely on the Inheritance Act claims because we're dealing with large estates normally, and normally it's going to be above 100,000. However, look at ILOT. Actually, what she was asking for was what she received was quite a lot less. So there is a chance that you may be on the intermediate track, which is a new track for proceedings valued less than 100,000 issued after the 1st of October. But note it's a new track for less complex claims, and I wholeheartedly agree with Luke. You're probably going to have to shore up your arguments that these types of cases are just too complex to be dealt with in the intermediate track, and they shouldn't be barred. We're only dealing with cases here 3 days or less, oral evidence limited to no more than 2 experts. We just want to thank you for joining us, and to remind you that there is another brunch taking place on the 30th of November. There will be a registration link found in the chat box at the end of this webinar, and there will also be a follow-up email which will include details relating to that. So thank you very much, and we look forward to seeing you again. Take care.
Thank you.